Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. It's nice to see you here. Hello, good night. It's nice to see you. Go ahead and put your questions in the comments now so that I can answer your questions. Tonight, I just want to focus on questions tonight. So start putting your questions in the comments. I'm checking out the comments right now. So put your questions in the comments so that I can see it. Hello, good evening, Julian on YouTube. It's nice to see you. Hello, BBB. Bernady, BB. Good night, BB. Hi, Crows. Nice to see you. Okay, so let me answer some questions here. And now you can ask anything that's immigration related. I know there are a lot of questions right now, so please put your questions in the comments. I'm American Indian. Can they deport me? So if you're an American, you were born here, they cannot deport you. Full stop. Can permanent residents go on closed loop cruises to Mexico? Permanent residents are able to travel. You just have to make sure that you do not have any kind of risk factors like a past arrest record. If you have a past arrest record, I definitely say put a hold on the travel until you fully understand the risk and implications of that arrest or the conviction. Love your hair. Thank you so much, BB. September 19, 2025, makes it 3 years. A friend filed his follow, but no approval yet. So I would say over 3 years now is the processing time. And, it's not out of the ordinary to that it's 3 years and he hasn't gotten it. It might go a little over 3 years. The processing time for them, I believe, is even in like over 40 months. But keep in mind, because their longest time is 40 months, doesn't mean that everybody's is going to be 40 months. How long of a wait, F2B, on married child? 5 to 7 years right now. If I overstay on my work permit, can I get a new permit while overstay in the US? Unlikely. Get in touch with us. It just depends on what kind of visa you have, but there are other options. And so we want to evaluate whether one of those other options could work for you. So go to the link in the profile, schedule time to talk to us. Let's get to the root of it and figure out a solution that works for you. Why is it taking long to get approval after a seemingly successful green card interview? Sometimes they're doing another background check, they have additional questions. Sometimes it's just takes a while for it to get right back to the officer. Sometimes they're sending it for a supervisor review. So I don't know what happened. And it sounded like you had a good interview, but there may be something that they're looking at that's still holding you up. So if it's been more than 4 months, do a case inquiry and see if you can get a response there. Can I travel on tourist visa while waiting on green card approval? It depends. There is a slight risk if you're waiting for your green card approval and you enter the country on a tourist visa. I've seen people travel like that. However, especially now, officers will tend to ask more questions, and if they suspect that if you come here, you're gonna stay in order to finish your green card process, they will turn you back around, and then create a whole complication in your green card case. So, but it just depends, right? If your case, relatives file an I-130 and you're not expecting a decision for another 10 years, they might treat that differently versus if you're waiting for a decision any minute now. If you're expecting a decision any minute now and you're coming in, they might be thinking you're trying to come to finish out your green card process here. And the officers at the border and at the airport, their sole job is to make sure that when you're coming here, you're not sole, I shouldn't say sole, but one of the things they look out for is when you're coming in with a temporary visa, that you are not coming to overstay, that you don't have any permanent intents. If someone has a work permit and SSN, and I didn't see the rest. Good night. What does it mean when they push back your progress time from 3 months to 24 months? It just means processing times are longer. It's going to get longer, guys, because of the fact that they're doing additional screenings. We just saw in the news that they are now going to review 55 million visas, that they've basically all visas. So that is, I'm pretty sure they're putting a lot of their efforts into screenings and all these different initiatives towards fraud screenings and anti-Americanism screenings and good moral character screenings, that processing times are going to get longer. It's just a guarantee. It's going to take hundreds and thousands of hours, extra hours, to get through what they're trying to do. So, you can definitely, this makes sense that your case would go from 3 months to 24 months. I have F2 visa. I have a baby here. Can I get a work visa? No. So it doesn't work that way. An F2 visa and a baby does not mean you'd qualify for a work visa. But give us a call. Let's talk about what your goals are and see if there's anything else that you could possibly qualify for. But also have a travel waiver. Do you think it's okay to travel now? Okay, so you have a travel permit and a work permit, a travel document and a work permit. Is it okay to travel? It depends on your case. So I tell each of my clients to let me know when they're traveling so we can look at their case, make sure that it is good to go. But keep in mind, right now, I'm extremely conservative, and my first go-to recommendation is just don't travel. Wait until your process is over. The conditions for immigrants, it's getting worse. Unfortunately, the thing about it is we're all, as immigrants, everybody is in the same boat. Citizens, green card holders, immigrants, there is a vice that is closing in on all immigrants, right? Whether you want to apply for citizenship, whether you want to go from your 2 year to your 10 year, whether you're undocumented and you want to figure out a way through. So I would say that one, just make sure that you fully understand your options. Make sure that you understand the risk involved in everything you do, right? Whether you're a green card holder, whether you have your work permit or you don't have your work permit, make sure you are fully advised and you get guidance along the way, because things are getting a lot more complicated, and you just want to make sure that you are safe, right? Because every action could possibly result in a risk to you, your status, whether you're a green card holder, whether you are even down to naturalized citizens, right? Even down to naturalized citizens are being told that they could possibly face denaturalization if something pops up in a red flag pops up in their background. So it's definitely going to be tedious. But going back to that question, is it okay to travel? My go-to answer is no, especially if you just have a travel document. If you're a green card holder, that's a different story, depending on what your background says. But a travel document, That does not give you status. That does not give anybody the obligation to let you back into the country if you leave. And so there's an additional risk there. How long does it take to get a court date after filing motion with VAWA approved? So it depends on the court. Many courts are backed up right now, and so you're definitely looking at possibly over a year, for those court dates. But keep in mind that once you have a VAWA approved, you may also get certain amounts of protection. I mean, VAWA, they do issue deferred action along with a VAWA approval. I'm not sure if they did that in your case, because I'm also hearing that sometimes if you're in removal proceedings already, they're declining to issue a deferred action until you sort out the court case. But congratulations, having a VAWA approved definitely gives you a great advantage in court. How are you? I'm fine. How are you? I'm married and have a green card. Can I apply for my son to come visit on a visiting visa? It really is going to, you can always invite your son, but keep in mind, you won't be the one applying. Your son has to apply, and it's all going to be dependent on his ties to his own country. I live out of the country and visit the US with my daughter back in college. I'm not sure what the question is. I was married to a US citizen, and they denied me because of my Nigeria divorce. I'm about to marry another wife, which is from my country. What's my chance? Is there any red flag? So I guess I have a lot of questions here. If they denied you based on your divorce decree previously, then it means that if they didn't see your marriage was previously legally terminated, then any marriage that comes after that, it's going to possibly face the same denial if you don't fix the divorce issue. So did you fix the divorce issue, first of all? What this, three sentences, which two are questions, is not going to tell me if there are any red flags in your case, because the information is not complete. Make sure if you have an attorney, talk to your attorney. If you are going to go ahead and apply, get an attorney. Now, I am saying, guys, it's important because no case is simple right now. Just the smallest mistakes can result in severe penalties because of the way that they're expecting applications to come in, their procedural steps now leave very little room for second chances, even marriage-based cases. Because a lot of people think, I'm married to a US citizen. I can get the green card because I'm married to a US citizen. It doesn't work that way. And you are basically, the way you're starting against the grain, because this administration is gun ho on screening for fraud. And sometimes when you go looking for something, you can find it if you're not on your top game, and they go looking for something and you do not properly submit your application, it could easily turn in that direction. And once they start to go down that road, your case is now a complicated case. So I really hope that the seriousness of the situation is getting through to you. Same with citizenship. A seemingly simple case can go bad very quickly because of the way they want people to submit their citizenship application. So make sure that you're represented. Make sure you're submitting those applications, no matter what application you're submitting, submit it the first time. Make sure you're investing in how your application is submitted, right? Because Here it seems like, okay, you got married, you got, they denied you because of the divorce. But if they denied you because, which is very common for them to look at the Nigerian divorce document and say it's not valid, but did you fix it? If you didn't fix it and you go into the second marriage and reapply again, but you didn't fix the first problem, they're gonna deny it again. And keep in mind too, if they see multiple marriages, they are gonna reopen the other one to review and once again screen for fraud. So it's very serious, and I emphasize this because I can see where somebody's case that is straightforward can go south. Saw that in the last administration, and I would say they're coming back 2 times harder this administration, right? When I say during the last Trump administration, seemingly simple cases went bad very quickly, took very long. In this case, they're 2 times worse than before, right? I mean, if you put a number to it, it's like it's escalated. U.S. citizen parent sponsor adult unmarried children prior to date 2018 case NVC. How long again for green card interviews? So is your prior to date current? 2018, maybe you're approaching the prior to date, but they'll definitely notify you if your prior to date is current and then start requesting documents. I would have to consult the National Visa Bulletin, be able to understand your case more to answer that question. But based on your description, it's about 5 to 7 years. So 2018 is approaching the 7 year mark. So I would think you're approaching that date, your priority date being current. You're going to get an email telling you they're ready to process your case and for you to for the petitioner to log into the National Visa Center portal to be able to start providing documents. But keep in mind, here's the other hard thing. And once again, we're going to see cases getting longer. So Lord knows how long this is going to be. But when your priority date becomes current, they're ready to process everything. Expect at least another year of processing. What's an affidavit of support? So an affidavit of support is required during the adjustment of status process. Whether you are going through family-based process or you're going through marriage-based. And it says that the petitioner has to show that they make enough money to support you, and they base it on your household size. And so household size, and then they look at your household size and determine, are you making enough for that household size? You can find the income standards on the I-864P form. So I-864P as in Peter is on the USCIS website. Look at that to determine whether your petitioner makes enough money or whether they're going to need a co-sponsor. You will not get your green card without that affidavit of support. During the last Trump administration, I saw a lot of people started to get denied based on the affidavit of support. So that affidavit of support is once again a piece of the puzzle that you can't get wrong. No, here the stakes are a lot higher, guys, because even through marriage-based cases and family-based cases, if you get the affidavit of support wrong, they issue a denial or they issue a rejection. They right now have designed a system where they're issuing notices to appear on auto, right? So rejection, denial, somebody is about to be out of status or is out of status, they issue notice to appear. The issue with that, but had that not happened, then they could go through a protected process, a smooth process to the end, get a decision and smooth the transition to the green card. But because there were mistakes on the affidavit of support, it was denied or rejected, they take that chance now to say, oh, and the spouse of the US citizen is overstayed. So guess what? No more affidavit, no more adjustment of status application. We denied that. So we're gonna go ahead and issue a notice to appear. The problem with that is once it goes to court, you can't fix it by refiling. Now you have to go to the court, and the court is a whole other nightmare. It's a whole other stress. Doesn't mean that you can't fight in court, but who wants to be in court before a judge? Who wants to have their case dragged out for possibly years, or having the risk of detention? So everybody's facing this right now. That's why it's important to make sure you're covered here. So if you don't know what an affidavit of support is, you are not confident, it's time to give us a call and get representation for sure. September 19, 2025 makes it 3 years. A friend filed his VAWA, no approval yet. I answered that. That's not out of the ordinary. Okay, let's see. When should one apply for a green card? Immediately after marriage, or how long should they wait? Great question. And there's no rule that says you can't apply right away. But what I would say is, once again, the stakes are a lot higher. So you should not be rushing to file an application that doesn't have everything that they're going to need to make a decision. You should be filing every application that you file. You should be filing it in a way that the officer is ready to make a decision just based on what they're looking at. Otherwise, you risk possibly getting a notice to appear if it's denied because you missed documents. So it takes time, right? It takes a little time. You're married. What I would say, if you're married, make sure you're working, even before you're getting married, make sure you're working on building your life together, documenting it, right? So as soon as you're married, you can file it. I have worked with couples that they became engaged and they retained me right when they got engaged. They know that, okay, it's time to prepare for the paperwork. They retained me. We sat down, worked together to show their lives before they were married, and then after they got married. Keep in mind that some couples, they have a long history together. They already have an account even before they were married. That's great, right? So, we gather everything that we need. And then as soon as they get married and they have that marriage certificate, we go ahead and file their case. And it makes for a strong case because they were documenting their life together even before they actually got married. And that shows a history between the two, and it shows that they're a bona fide couple that are intending to spend their lives together. But if you if you have watched me, if you followed me, you know this example already. If you went to Vegas, you went to Vegas, Friday night you went out partying, you met the guy that or the lady that you said is the love of your life. You get married, you elope that same night. Would you file the papers on Monday? I don't think that would be a good idea because you just met. Even though it was love at first sight, you just met. You have to build a history together first before you file the papers. It's gonna take maybe a month to do that, to know who's gonna move where's your home gonna be, what bills do you have to pay together, how are you gonna share in the funds. So that's an example of when you could file right after marriage, when maybe it's not such a good idea and you need to take some time to do that. If she has a pending VAWA, so let's see. Can I still apply for a green card? I'm married to a U.S. citizen. She disappeared, but the divorce never granted, but it was filed last year. Get in touch with us. Let's talk about your circumstances. We want to hear what's happened because you may be able to move forward without that spouse. But we have to understand your circumstances to be able to tell you whether you qualify for that special process, which is VAWA. If she has a pending VAWA and wants to file an I-130, does it make sense now under this admin? And does the prima facie hold any protection anymore? So keep in mind, you qualify for something, you should be applying for it. It makes no sense to qualify for a relief and you don't qualify for it. You don't go for it, right? Because you are exposed anyway. So you should always pursue the legal option. Now, filing an I-130 could present a risk, and this is where it's very important to get at least take that first step to talk to an attorney. I can't tell you how that can at least free your mind, at least help you to know your options and move forward with a great option if that's the case after the appointment. But in this case, before you file anything, understand the risk, understand how it will affect you individually. Because some I-130s, I would say this, filing an I-130 without an adjustment of status, and you are in a situation where you've overstayed or you've entered the country without inspection, is going to be a risk for detention or referral to immigration court through a notice to appear. Now, there are certain application types where you can apply for it, even if you overstayed and even if you came into the country without inspection, like VAWA, like the T visa, U visa, asylum. Those are some options that they are not going to hold that against you. And the risk is much lower in that case because the whole point is you're seeking protection. Now, so does it make sense under this administration? If you qualify for something and it makes sense to you, go for it. Do you qualify for something under the law? You should be approved, but you need to approach it smartly. That's where I think a lot of people may fall into a trap, is not approaching the process in a savvy, smart way that reduces their risk of a notice to appear or detention. No, prima facie. Does that offer any protection? I would say this, we right now we're at the front lines, and I can tell you that my observation is those clients who have a pending process, which the prima facie shows, are we've been able to get them out of detention just based on that, right? So to that extent, that can offer a level of protection. It can also offer a way to be able to show an immigration judge and maybe even ICE that you should be released or your proceedings should be terminated. So the prima facie, I would say, still holds a level of protection. The T visa also offers bona fide and the U visa bona fide determinations that clearly state on it, issued by the USCIS, that says all removal holdings are placed on hold. So those offer protection while you wait on your process. A lot of questions. TikTok, I'm coming. I'm just trying to get through as many questions. And YouTube, Facebook, I'm coming as well. I just want to see if I can get through a lot of the questions. On Instagram, how long can you file after entering the US on a visitor's visa after being married for 1 year to a US citizen? So you can file right now, but as I said before, approach these applications very carefully. So you can give us a call and get representation. If not us, make sure you're talking to an experienced immigration attorney because it's that serious. Shamika, I did not see your question. Okay. I was on H-2B visa, but got married and we both have a toddler, went in for interview and all is well. Okay. So I don't know what the question is then. I guess put your question in the comments again, because I think I missed it. How long? So I answered that. I would like a consultation. The other good news is we are 24/7. We are running the phones 24/7. Go to the link in the profile, schedule. Now we have attorneys that work closely with me. Our attorneys have the same approach as me, and they are as experienced and knowledgeable as me, and they work very closely with me on complex situations. So go ahead, schedule, but start with our form if you want to schedule on your own, or give us a call and the team will be more than happy to assist you. Can you use your travel permit under this administration? I would say the risk is higher. I am tending to go towards just wait on your case to be finished. But I understand that people do have, emergencies, and the travel permit is there for that, or travel document. I came on H-2B having I-94 contact. A lawyer told me I need a work permit, and he seek asylum for me, which I didn't want. I wanted work permit with travel document. So be very careful, guys, about, I don't know if this is a lawyer. Some people claim to be lawyers when they're not. There's a lot of fraud going on. So be very careful. And keep in mind, there are even people who are impersonating me. So make sure you're going to our official website. You can start here on the platforms by clicking only the links on this platform to get to our official page, to see our phone number, to get to, fill out any forms that we have. Those are ours. But be very careful who you're working with, who's saying they're lawyers. Now, why I say this may be concerning, and you want to make sure that you fully understand what happened, is if you didn't want asylum, how did this person end up applying for asylum for you? Because my concern would be, did they submit a fraudulent application or a frivolous application that can get a lot of people into trouble? So you need to get legal advice, a second opinion, to make sure that you're on the right path, and maybe how to fix it if they did something wrong. I'm stuck here. I have to find someone to marry before I can go home. And I understood. So what we do is we don't focus on that. If you do have a spouse, yeah, we're there to help you and your spouse. If you have a spouse and you can't apply with that spouse, we're there to help you through that process too. If you cannot get married, because we cannot just go pick up spouses off of the shelves. Unfortunately, it's not that easy. And you do find yourself in very vulnerable situations when you're rushing into that process. So we also look at options where you don't have to do that. So the fact that you may have been the victim of fraud here, I want to know more about your story, because that's usually where we're able to find solutions for you. Because it sounds like you're going through a lot. Sounds like people are leading you down wrong pathways, and we want to talk to you to figure that out. So give us a call and schedule some time. That's so true. A lot of fake lawyers. One asked me for $5,000 for VAWA. Thanks for clarifying. Absolutely. That is happening, guys. And people are, when we screen for cases, we are screening for good cases that qualify for whatever we're applying for. If people are just telling you, oh, you'll get the work permit, and you're like, okay, what does it all entail? Don't worry about that. Just know you're gonna get the work permit. Don't worry, it's too good to be true, right? You want to understand, why do you qualify for this? For example, with our attorneys, we explain, how is it that you're qualifying? What do you qualify? What are you getting out of this, right? How long is the processing times? If this person is just saying, we can get this for you, we're going to get without explaining, that's another story. All right. So make sure you. Okay, definitely. I want to hear, I want to talk to you. And keep in mind, you talk to our attorneys, and they want to hear your story as well. They'll ask you very pointed questions to get to the root of what you've been through and see what options you qualify for. So is that you're saying if you have a pending VAWA, prima facie, waiting on approval, she would have already overstayed based on the filing applications? Is it a matter of if or when? Yeah, so this is where that's exactly, I think that's the confusing part for a lot of people is they think just by applying, you're going to be deported if you overstay. Some people can qualify for benefits even if you overstay. It's just a part of it. Most of our clients, T visa applicants, VAWA applicants, marriage-based applicants have already overstayed. The law says that it's okay, but where they will get you is if they deny that adjustment of status. Now they have a space to issue that notice to appear because now they're saying we denied the I-485. They don't qualify for that, so we're issuing a notice to appear. So keep in mind that bottom line, do the case properly, that risk goes down. File the right applications, that risk goes down, right? So when we're seeing the news articles that says applying through a spouse, applying through family member, petitions can get you deported, it's very vague. And I think it's even a little misleading. But what I would say though is the headline is justifiably alarming because most people are not experts. They don't do this on a routine basis, just like we do this on a routine basis. So if they try to do it on their own and they get something wrong, they don't know, maybe they didn't file this or they didn't know the procedural step for that, or they didn't know what was required here and they miss a document. What the policy manual says is we can decide you don't get a second chance. And then if we review your case, so like you send in your packet and say you forget the affidavit of support, since we were just talking about the affidavit of support, you miss the affidavit of support. They are reviewing it. They see, okay, you would have qualified, but you missed that affidavit of support, which means we have to reject your application now. We're going to send it back. And guess what? Since now we see that you've overstayed and technically you did not properly file an adjustment of status, but now we know you've overstayed, we can issue this notice to appear. And that's going to throw a wrench into your plans because once you get that notice to appear, you're going to court. You're not going to be given that the USCIS is going to say they have no jurisdiction, no ability to make a decision on your green card. You need to talk to the judge. Talking to the judge is going to be a year or two, and it's going to be very stressful because of the fear surrounding going to court and so forth. So file it properly, understand what you're filing, understand how filing this raises your risk or reduces your risk. Make sure you're doing everything procedurally correct, you're including all information because they're saying that they have the right to not give you second chances and they have the ability to review your application. If they see anything and you don't qualify for the right documents or statuses or protections, they will issue that notice to appear. I was married to a USA first time. It took 10 years to divorce. We never filed anything. Years later, I get married to another one that filed for divorce last year, never filed anything but moved back. So give us a call. Let's talk. It sounds like you've been through a lot and we want to see what options are there for you. Can I still apply? I'm stuck here. I'm French and I overstayed. If I would want to understand what happened in the marriage because you may be able to proceed without them. But the clock is ticking now because if the divorce you said filed for a divorce last year, never filed anything but moved back. So give us a call. Let's sift through your facts because there may be options available. All right. Now I'm on TikTok. There's a ton of questions coming in. Hello on TikTok. I'm going to answer some questions. We all can learn from the questions. Thanks for your patience. My son, I-130 have been approved. Can we file the adjustment of status? He will be 21 years next week. Okay, so are you a US citizen or a permanent resident? Keep in mind that's going to determine whether he will age out or whether his age is frozen from the time your petition was filed. So it could go if he's here in the US, an adjustment of status must be the next step, but you want to make sure he actually qualifies for adjustment of status. And that's going to be dependent on your status and whether you're a US citizen or permanent resident. Is it possible to challenge the misrepresentation criteria if you don't qualify for a waiver? Yes, it's always possible to challenge those. There may be options like going to federal court to have that part reviewed for the misrepresentation, or simply doing an appeal or a motion to reconsider to challenge it. That could also, because sometimes officers make mistakes of law and it takes that to be able to change things. From asylum to green card via marriage, what's the risk? It depends on what's going on in your case. Now, they're screening for fraud and they are honed into as both asylum and the marriage base. I mean, they're looking at everybody and everything right now. But aside, if they're asylum, they want to make sure you didn't file an untrue asylum. And at the same time, they want to make sure you're entering a real marriage. Also, it's asylum defensive asylum. Are you in court already? That's going to make a big difference. Can they still apply for adjustment of status for a marriage base? Yes, absolutely, guys. It is in the law. The INA says it. Spouses of certain relatives of U.S. citizens, spouses of U.S. citizens can apply. The law has not changed, just the way that they're going to be doing things. And I would say the way that they set up everything, they have set it up in a way that you have to be on top of how you're applying, that you're submitting everything. That's where the success is going to be, in submitting everything correctly. If someone had admin closure from an asylum case to apply for TPS, but it's now canceled. So they are reopening cases. I don't know if that's what you're saying. If it's canceled, the admin closure is canceled, they're reopening the cases. Yes, they're doing that. You have to make sure you respond in order to counter that reopening motion to reopen. Can you re-enter the US without an entry permit as an LPR with a valid green card out of the US for 2 years? They could issue you a notice to appear upon arrival to the US, which means that they would try to revoke your green card and they might detain. So a re-entry permit might be a safe way to approach it so you don't end up in a situation where you're detained at the airport, or they issue a notice to appear to revoke your green card. I'm going through. Does applying for bankruptcy? Um, I'm not sure. So does applying for bankruptcy, I think, does it affect the case in these times? Anything to do with, because now they have this anti-American evaluation that they're doing, and it's focused mostly on national security and anti-Semitism. But keep in mind, if there is something in your background that maybe stands out to them that they would categorize as out of the ordinary, then that could present an issue. Okay, does applying for bankruptcy affect asylum decision? It should not. It shouldn't, but keep in mind they're applying, and they are applying anti-Americanism analysis to everything. And one of the things I could so see them saying, you know, you've if you're in the country, how is it now that you've applying for asylum? How is it now that you've gotten to the point of bankruptcy? They will evaluate why your financial what how is it that you got into that situation, and was there some kind of wrongdoing associated with that? So even though that's not supposed to be the case, I can so see that could possibly raise some questions for them because they are implementing the anti-American analysis to all applications. Can you enter the U.S. without re-entry permit? So I answered that. Extension I-75 can you travel out of the US? The extension allows you to show you continue to be a green card holder, so you should be able to travel. Just make sure there's nothing in your background that raises risk, like an arrest. For example, we just saw in the news a green card holder was detained coming back from vacation because she had a marijuana conviction 20 years ago. So she thought this was long past her, and now a nightmare is beginning, right? Just 20 years after the conviction. So that's an example that anything in your past, you need to evaluate whether it's going to affect you. Can an attorney do something for your case I-485 being paused? It depends on the reason. You definitely have to talk to an attorney to figure out what it is. Why have they paused it? Is it they're non-responsive? Is it taking too long? We need to understand the situation to see if there's a way to challenge it or get it started. Can you file for adjustment of status if your child is 21? He came on a visa. So I think this goes to the same question. It depends on, are you a US citizen? If you're a US citizen, your child is under 21, now you said, I think you said the petition is approved, you can move forward with that adjustment of status. If your child, but once again, do it correctly. If you're a permanent resident, your child came on a visa, they overstayed, adjustment of status is not going to be the option. So definitely talk to an attorney. Petitioner to be scheduled for biometrics for I-130 for spouse living abroad. Is that normal? No. So no, it's not normal for biometrics to be done for the spouse outside of the country. If there's an issue, maybe that's why they've done that, if they suspect, unless I'd have to check to see if they changed the policies, but as far as I know, that's out of the ordinary. Usually they're focused on the relationship and not necessarily the background of the person. Petitioner to be scheduled for biometrics for I-130. Oh, petitioner to be scheduled for biometrics for I-130 for spouse living abroad. Is that normal? That's also not normal. If they do suspect that there's something in the background of the petitioner that could render them banned from sponsoring somebody, like under the Adam Walsh Act, that could explain it. Is it still safe to get married in the USA on a visitor's visa and do adjustment of status? I would say yes, as long as you do it correctly. Do it. I say this now, everything is as it was before, except the procedures that they have adopted behind the scenes means that if you miss a step, your risk goes up. So I say risk goes up when you're not applying properly. This goes for everybody. Citizens, same thing. Green card holders, same thing. If you're applying for green card, 2 year to 10 years, same thing. Visas, same thing across the board. they are implementing policies that you miss a step, it could have consequences. Is marriage green card processing time faster now than before? So new, no. So I would say I would say, the same, about a year to get an interview. I expect it to be longer though. What's the cost of consultation? $150. You can call us. My numbers all over the screens of my the all over my videos. You can click on the link in the profile as well, to get to my website to be able to book your own appointment. And thank you so much for the love on TikTok, by the way. I really appreciate it. And the great questions. Did my marriage and great questions on Instagram and YouTube and Facebook. I'm coming. Did my marriage interview on 28th July, but my status is showing I-821 with no updates. So they may take some time to decide. So I would say 4 months is definitely outside of the time. I filed for my brother and sister since 2013, approved. Asked NVC and they wrote back no visa. So no visa priority date. With no visa priority date, they're not going to process the visa. Are they looking at how many years you and your partner been together before marriage? That counts, but it's not going to get your case denied. It doesn't make or break your case. Any two people can. They are looking at your intention to live and build a life together. What is a robbery case eligible for? If there is, we have to look. So robbery alone doesn't necessarily qualify one for the U visa, but we have to look at the elements of the crime, and then we can determine whether it qualifies you if you're the victim for a U visa. U visa allows you to get deferred action about 2 years after applying and gives you the work permit and the travel document. Now, one thing I've been hearing lately is, oh, that takes so long. I need something right now. Usually, when we are evaluating cases, we are evaluating the best options, and there's no such thing as getting a work permit today, right, or within a month. No such thing. If somebody's promising you something like that, it's a scam, right? There are certain timelines for these things. And what I would want to say here is it's your decision whether you're going to stay undocumented and face the risk, or you're going to go for something you qualify for. But the people who are with me, who a year ago, when I had told them the timeline, and they themselves also thought it was a long time, but they went forward with it because at the time it was the only option for them. They're winning now, right? So if I say, if you don't make a move, it's never going to happen, right? So if you keep saying it's going to take long, it's going to take long, it's going to take long, and you delay because of that, and then now you regret it because you're facing something scarier, now you're ready. At that time, it may not be that simple or straightforward. Now it's more complicated. You may not have access to that kind of relief. So that's where I say, don't applying alone can put you in a position, in an advantageous position, because you can. I've seen it with my own eyes and with our own team working on cases where we have been able to seek release of clients that have pending processes. Now, it's not to say it's guaranteed you apply, you get protected, but it gives you the ability to advocate. It gives us the ability to advocate for our clients. All right. Can we, as USCIS, apply the February 2023 CSPA policy instead of August 2025 policy to protect Bro from age old? No, if the policy is in place, they have to go by that policy. So the August 2025, unfortunately. Is it okay to get married on a visitor's visa and return and still visit with the same visa? So it really comes down to your particular situation. Um, getting married and then filing the papers and coming to visit on a visa can raise questions coming in. So you just have to understand those risks. All right. I'm going to go to Facebook and YouTube now and answer questions there. Hello, good night. Do I need to do annulment after my case was denied due to divorce? Though I fixed it and I'm about to get married again to a different woman. So it sounds like you're divorced already. I don't know why you were denied. Was it for the green card? I'm spacing out on that, but it depends. If you're applying for VAWA, annulment can take away your qualification for VAWA. If so, it just depends. Definitely talk to us in an appointment. We can get to the root of it and determine what's best for you going forward. What about the new citizenship stuff? So the way that citizenship is going to work now is you're going to have to put it together like you would a really good, maybe even more than a job application. The way what they're asking for is even more than a job application. Um, if you were applying to be a saint, and you had to if that was a thing, you were applying to be a saint and you had to show why you deserve to be a saint. That's sort of how the citizenship application is going to be. You have to show all the good things you've done, the constructive things you've done, right? So I already have know exactly how we can present the applications to put our citizenship clients in the best position possible. That's definitely my strong suit as an attorney. And so it's emphasizing the positives. It doesn't mean no, when I say that about the saint, it doesn't mean you literally have to be a saint. Like you have to show you're going to church, you have to show volunteer work, but you have to show what are the positives that have contributed to the United States that that really enhances your good moral character. And all of us can talk about those things, right? So you have to focus on those things and gather the documentation that show those things. You've worked continuously, you've worked on your education and your constant advancement, you've taken care of your family, maybe you go to church, right? And those can be supported by documentation, your tax records, your employment letter. You can show letters from your pastor. Now, if you do, there are is happening though is even people with even people with minor traffic violations can possibly be denied citizenship if they don't show how the positives outweigh this negative, right? So, for example, if they look in your community and they see people rarely get traffic tickets and you have 5 traffic tickets, that's probably going to be a big red flag for the officer, and they're gonna say they deny unless now you show how you've corrected that, how you're rehabilitated, how have you approached it. And I know it's hard to believe that that's the case, but that's what they're looking at right now. That's the extent to which they are demanding proof of good moral character, right? And expecting people to, I mean, I think many of us know what it feels like to get a traffic ticket. And to think that that could go against one's good moral character is crazy. But that's where we are. And that was actually stated, by the way, in the manual, right? That non criminal matters that based on the officer's evaluation of the average citizen in your community's behavior, if it's outside of the average person in your community's behavior, they can turn around and say, that's really a bad reflection on your good moral character. So once again, that's why I say everything, every single immigrant, they are facing where everybody's in the same basket, right? So it's crazy that a lot of people before this administration believe that it would be the worst of the worst that would be targeted, and I would say it's because it affects every single immigrant in such a negative way. It really has targeted even the best of the immigrants, So just make sure you're approaching everything carefully, you're understanding how it needs to be presented, and don't let it intimidate you, right? If you've done everything right and you don't have volunteer work, don't let it intimidate you to feel like, oh, I can't be a citizen now because I never volunteered. That's not true, right? But you need to tell your story to show the positives. All right. Good evening. Hi, Francine. I file 102. How long does that take? I'm not sure what the 102 is. Did my biometrics a month ago and my marriage based interview a month ago, but my work authorization is yet to be out. What can I do to hasten it, please? There are ways to expedite it if you have an emergency, if you can show that somebody's going to suffer significant financial loss, if you're in healthcare or you deal with childcare, that you work in the healthcare industry or the childcare industry, or you're about to get a job and the employer needs you to start working, you can show that that employer needs you to start working. So there are different ways to approach it, mainly to get an expedite request. Hi there, Karen. Good night. Quick question. I'm an American citizen. How long will it take for my wife that lives in Panama through the consular processing? Expect 2 years, 2 to 2.5 years. How many pages must VAWA affidavit be for the petitioner? There's no one size fits all. It's what's your story and how many pages is it going to take to tell, and are you including the relevant information? That's essential. What are you putting in the document? Because if you put information in that affidavit that does not help the officer to make a decision, you're still going to be in trouble here. So it's not necessarily how many pages is required, it's how many pages will it take to tell this story with the relevant information that the officer needs. Hi there, Manoj. Nice to see you. What do they mean by you need to contribute to the community to be a citizen? So, for example, volunteer work, right? But that is not one of the requirements. That's one of some of the things that you can show as positives, right? So I don't want you to think if you did not volunteer, you don't qualify for citizenship. But you need to highlight the good that you've done. If yesterday we talked about being a stay-at-home uh, spouse. If you're a stay-at-home spouse, you're supporting your family, in their daily endeavors. You're there holding down the fort while they're out there working. That is a positive that you need to highlight, right? So that's why I say, and that's definitely our strong suit at here at ST Law Office, is our presentation of the applications. So we're ready for this change. It's the way you present it, the way that you have to basically put to it's going to involve being able to put the right information in that document. That's true. I'm not saying make up stuff, but to put your true information in there to highlight who you are, tell your story, and how you are constructive, and how in just by being constructive, right? Just being supporting your family, you are contributing to the United States, right? So know how to do it. If you don't know how, that's what we're here to do. That's So give us a call. Can my spouse file for me as a spouse filing if they're a US citizen, if they're a permanent resident? Yes. Are you here in the US or not? The way it's going to work is going to depend on that. When you enter the US as a visiting, how long will it take for you to get married? You can get married at any time, but you want to be strategic about it. You want to understand how to approach it. Get in touch with us. Let's talk. Get advice before taking any action. My notice of action category was C9 and it was changed to C31 on the newest one. What does that mean? So C31 is for an approved VAWA. So C9, if you, and it depends, did you file your petition and did you file it with the adjustment of status? If you file the VAWA petition with adjustment of status, that's supposed to be C9. If you file an I-360 alone, a C9 doesn't apply there. So they may have corrected it to the C31 category. Or it may be an error. So it just talk to your lawyer to make sure that it's done. How long for a BFD T? So it's taking 3 to 4 months for the receipt notice and then about another 2 months for the biometrics. So right there, we're dealing with 5 months and then another 2 to 3 months for the bona fide. So that's about another 3 months for the bona fide. And then after that, about another 4 months for the work permit. Keep in mind the bona fide determination offers protection against removal. So it's a valuable document to have. All right. Good evening. How do I answer question 22 on page 14 for I-485? I'm under MPIP. My I-130 was approved last September. Thank you. So I do not advise I can't advise you to answer any specific questions on the forms. I would be actually putting you at risk for just blindly advising you how to answer a question like that, especially if you're a military parole in place. So this is where I say representation is solid, is very important, because putting the wrong thing now is not the time to dilly dally with that. So, if you have your attorney, talk to your attorney. You don't have an attorney, get one. It's the investment right now that you should be making, especially, it's really tragic. It's really tragic when you have a case that can go through smoothly as long as it's presented properly, but you miss that step, and because of that there are complications. It's tragic. I don't want to see it happen, and this is where I'm saying get an attorney. If it's not us, talk to your attorney. You said bona fide. So a bona fide determination letter comes with T visa, it comes with U visa, it comes and it gives you protection while your process is going forward. If you have been removed but have no crime, can you come back to the US? There may be ways, but we'd have to understand your particular circumstances. Good night. I received an NTA a few months back, but yesterday I received a new mail yesterday saying my master hearing is in 2027. Does that mean my November court date is not holding anymore? So if you go to the EOIR case status, so it's on the EOIR. Just Google EOIR case case check or case, I think case status. If you put your A number in there, you'll see exactly what's happening there, and call the court as well. You don't want to miss that hearing. So you want to make sure you are on top, but keep in mind, you have a notice to appear. No, it's not, and you have it in 2027. No, it's not the time to sit back and wait. Make sure you are looking at your options, because options can get you out of the removal, especially since it's scheduled so far out. It can give you time to get out of the removal, or you can go before the judge and get the relief in front of the judge. And that takes time. It takes planning, guys. So make sure you're not waiting last minute to follow through with the NTA or to plan around the NTA. because at that point it's essential to understand what uh, defenses do you have to defend yourself against removal in court. All right. Thanks so much, everybody, for your time. I really appreciate all these great questions. I'm going to be back tomorrow. I've been here Monday, Tuesday, Wednesday, Thursday, and Friday. So I am so glad I'm back on the 5 day a week schedule. So count on me being here tomorrow. Go ahead, give us a call. You want particular legal advice and representation, it's time to give us a call. Evaluate your options. Go to the link in the bio, and you'll see all the links to be able to access information. Only access information on these platforms, and do not give money through PayPal or Zelle or Cash App. We don't accept money through those platforms. So just be wary about fraud, scams, and that goes across the board, guys. So use the official links that are on these platforms to contact us. You can even DM us, by the way. Go straight to the DMs, DM us, and we'll help you. We are 24/7, so give us a call and let's get started on looking at some options for you. All right, have a good night, everybody. See you tomorrow. Remember, like, share, subscribe, follow, hit the notification bell. Do all of that so you can see when I come on again, and you can come on. And also, this enables other people to see information that empowers them through this immigration journey. Alan, you're very welcome. Thank you so much, everybody. Have a good night.